Good morning, everyone. I want to thank you all for being here and for joining Attorney General Bonta and I. I'm Kris Mays, the Attorney General of Arizona. The president ran on a promise to lower costs for Americans and Arizonans, but the cancellation of the Solar for All program does exactly the opposite of that. It will raise costs for low-income families who are already struggling to pay their electricity bills. The Solar for All program was a $7 billion national investment in energy cost savings and renewable energy that directly helped consumers. Arizona received nearly $156 million to administer its own Solar for All program. Adding affordable, reliable, distributed electricity generation to the Arizona grid, which would generate $165 million in savings for Arizonans and create new, good paying jobs across the state. More than 11,000 low-income households in Arizona will see higher bills thanks to the Trump administration's cancellation of this program. On average, those Arizona families and businesses will see a 20% higher electricity bill without Solar for All. Without federal investment through the Solar for All program, Arizona will not be able to offer new low and no interest loans to single family households, offer grants to nonprofit or municipality partnerships to develop neighborhood solar projects in low income and tribal communities, offer grants for distributed solar plus storage to tribal and rural homes that lack electricity access, or distribute resulting savings via monthly utility credits. It is estimated that 15,000 tribal households in Arizona lack any access to electricity, and many tribal communities that do not have electricity often experience outages due to aging infrastructure and lack of investment, especially in the dangerous summer heat. For instance, the Hopi tribe, which is located in northern Arizona, was slated to receive a $25 million award from the EPA's Solar for All program, in addition to the $156 million awarded to the state of Arizona. The tribe planned to bring electricity, often for the very first time, to hundreds of homes on the tribe's reservation with distributed solar and battery storage systems. Without Solar for All, the Hopi tribe and many other tribal communities across Arizona will lose access to critical energy infrastructure that they desperately need. It's not just home and neighborhood solar programs put at risk. Millions of dollars in support funding for essential industry stakeholders have also been canceled by the Trump administration. Some examples include $33 million to integrate rooftop solar into the purchase of new homes, canceled. 11 million to support thousands of new jobs for energy infrastructure, gone. And the $16.7 million that Arizona was planning to use to support community lenders that help small businesses and families transition to solar energy, DOA. Beyond the financial impact, the health and safety impact could also be significant. Without the crucial investment of the Solar for All program, Arizona's utilities will have a more difficult time reaching their voluntary carbon neutrality goals by 2050, which will, of course, impact Arizonans' air quality and overall health. The canceled projects were expected to help Arizona avoid 2.4 million tons of carbon dioxide emissions, representing an average drop of 42% in annual emissions avoided per participating household. Without Solar for All, Arizona will see more particulate pollution, nitric oxide and sulfur dioxide released into our atmosphere. The loss of the Solar for All program will also make it more difficult for Arizonans to meet the projected 40% increase in energy demand in the coming years, leading to a less reliable, less resilient grid and higher electricity bills for Arizona households and businesses alike. The unprecedented illegal cancellation of this critical program is simply unacceptable. Without this program, for many Arizonans, clean energy will be out of reach. Beyond the fact that this energy infrastructure funding has already been appropriated to our states and is owed to Arizonans, protecting solar projects and lowering electricity bills is personal to me. Arizona families are already facing sky-high electricity bills, and we will not let the EPA abandon its commitment to fund solar energy projects that would lower costs for more than 900,000 Arizona households. I have made a career in Arizona by protecting Arizona consumers and safeguarding renewable energy and the subsequent lower costs that it leads to. And I am not going to back down now. And now it's my great honor and pleasure to introduce my colleague and friend, Attorney General Rob Bonta. Rob.
Thank you, AG Mays. Wonderful to be with you as always and to team up and partner as we defend the rule of law. Good morning, everyone. Rob Bonta, California Attorney General, and I want to say thank you for joining us this morning as we announce the latest lawsuits, plural, that we're filing against the Trump administration. Trump's Environmental Protection Agency has, as mentioned, unlawfully shuttered the Solar for All program, terminating $7 billion of grants for programs across the nation. And these are programs that would help lower income and disadvantaged communities adopt solar energy, lower energy costs for consumers, promote energy independence, and create new green jobs. In California, we stand to lose almost $250 million, a quarter billion. By cutting off these congressionally obligated funds, Trump's EPA is violating its contracts with each of our states, acting far beyond the scope of the agency's authority and violating the separation of powers and the U.S. Constitution. Simply put, Trump's EPA is in breach of our contract and acting unlawfully, which is why we're taking them to court twice. Before I dive into the details and the impact of this illegal action on California, I want to acknowledge my fellow attorneys general who've taken the lead on these two lawsuits. Arizona Attorney General Kris Mayes, Maryland Attorney General Anthony Brown, Minnesota Attorney General Keith Ellison, and Washington Attorney General Nick Brown. Amazing leaders, amazing colleagues. Thank you for your leadership. I'm proud to join them in filing these lawsuits today, which together mark California's 43rd and 44th lawsuits against the Trump administration in 38 weeks, more than one a week. Yesterday, we filed the lawsuit in the Court of Federal Claims to ensure we get the funding states are owed. Today, we're filing a separate lawsuit in the District Court for the Western District of Washington to declare EPA's actions illegal and require EPA to reinstate the Solar for All program in accordance with Congress's direction. I also want to thank the members of California DOJ's Bureau of Environmental Justice, the Environmental Justice and Protection section, and the Natural Resources Law section, who are working diligently to represent the people of California and the primary grant recipient, the California Public Utility Commission. In this case, you'll hear from CPUC momentarily. Let's just start from the beginning. Congress created the Solar for All program as part of the larger Greenhouse Gas Reduction Fund, which stemmed from the Inflation Reduction Act. Congress, which the Constitution designates the power of the purse, appropriated $7 billion to the states, including almost $250 million to California, to follow through on the mandate of the IRA and to achieve the goals of the Solar for All program. As an agency under the executive branch, the EPA had no legal right to terminate this congressionally approved program or rescind funds that have already been obligated to the states. While EPA Administrator Lee Zeldin spouted off in a post on X that the so-called Big Beautiful Bill eliminated the program, that is actually dead wrong, not true. The bill clearly states that only unobligated funds were rescinded. The Solar for All funds were already essentially fully legally obligated, following all of the required processes and procedures when President Trump signed the One Big Beautiful Bill into law. Our states work in close cooperation with the EPA, worked in close cooperation with the EPA for months to create clear plans for these funds, which the EPA approved last year. EPA formed binding contractual agreements with each of the states, and it breached those contracts when it baselessly terminated each of those agreements in August. The Trump administration may think that an ex post is the end-all be-all, but I'm here to tell them the law still stands. The law still governs. The law is still determinative. With these lawsuits, we're asking the Court of Federal Claims to rule that the Trump EPA breached its contract with California and award us and the other states money damages. We're also asking the District Court to declare that the Trump EPA's termination of the Solar for All program is unlawful and to require EPA to reinstate the Solar for All program. This is just the latest example of the Trump administration's sham promises to save Americans money, bring down costs, create more jobs, and strengthen American innovation. Gutting this program, in fact, does the exact opposite. Solar for All would have enabled more than 900,000 households in lower income and disadvantaged communities across the country to access low-cost solar energy, meaning lower electricity bills and cleaner air nationwide. Here in California, the California Public Utility Commission was set to receive $200 million to build mid-scale community solar power systems in the territories of the investor-owned utilities, PG&E, SoCal Gas, SoCal Edison, and San Diego Gas and Electric, which would offer 20% monthly discounts on electricity bills for participating households, primarily for lower and middle income families. These community solar systems could be installed on warehouse roofs or in parking lots, and nearby neighbors would be able to tap in to the energy generated and get discounted rates in return. A small portion of the funds for California, approximately $25 million, would be used to establish solar projects for low-income residents living in the territories of publicly owned utilities like the LA Department of Water and Power and the Sacramento and East Bay municipal utility districts. This includes community solar projects, multi-family rooftop solar, or single-family rooftop solar. Another $10 million would be used to get multifamily affordable housing units up to date with the infrastructure needed to install solar. California's piece of the Solar for All program also included $9 million for workforce training, enabling more California workers to take on green jobs and gain marketable skills in solar installation and energy storage to take them into the future. These funds have been obligated. Plans have been made, approved, and begun. Multiple state agencies have spent thousands of hours preparing to unveil these solar programs in California. Projects that are well underway are already being halted, creating an undue financial and administrative burden for our state for absolutely no lawful reason. California and our fellow states are owed the funds we've been granted by Congress, and which EPA in turn committed to us. Instead of supporting agencies like the California Public Utility Commission and the California Energy Commission in building innovative infrastructure that would catapult our state and country into a cleaner, more energy-independent future, the Trump administration is trying to hold us in the past, tethered to fossil fuel companies. In doing so, Trump is making America more expensive and more polluted. Meanwhile, other countries are outpacing us in the global race toward clean energy. China, Trump's top competitor, is lapping the U.S.'s clean energy growth and bringing down its reliance on fossil fuels, while America's is only climbing. Solar for All is a real opportunity to introduce more clean energy throughout the country and cut costs for American families who continue to be buried by rising costs and high monthly bills. It's an opportunity to address our climate crisis, secure America's economic competitiveness, and strengthen our energy independence. If that's not enough for the administration, maybe this will be. Terminating Solar for All is unlawful. It's a breach of contract and a violation of law and a violation of the U.S. Constitution. My colleagues and I won't stand idly by while Trump's EPA breaks the law, threatens our future, and throws our clean energy goals into chaos. We'll see the administration in court again. Before I hand it over to our next speaker at the CPUC, I want to again acknowledge the team at the California DOJ who've dedicated themselves to this case. They don't do it for the limelight or the recognition, but I want to provide them a moment of recognition for their great and hard work. Mary Logan, Dylan Redor, Rebecca Hunter, Theodore McCombs, Abigail Blodgett, Mi Young Park, Daniel Sheehan, and Nick Green. Thank you. And now let me turn it over to the CPUC President, Alice Reynolds. We will circle back at the end for questions. Take it away, President.
Thank you, and good morning, everyone. I'm Alice Reynolds, President of the California Public Utilities Commission. I'm pleased to stand with Attorney General Bonta, Attorney General Mays, and other states in challenging the U.S. EPA's decision to terminate the Solar for All grants, a decision which undermines the rule of law and harms Californians. This federal administration has been clear that it wants to block deployment of clean and renewable energy such as solar and wind, and will violate the law to do so. These efforts are pointless and harmful. California has been at the forefront of developing clean energy for a reason. Solar, storage, and wind are crucial to delivering safe, reliable, and affordable energy to customers in California and elsewhere. The federal administration's actions are driving up costs for ratepayers. They are needlessly slowing new generation at a time when load growth is increasing, jeopardizing grid reliability and economic growth. We are here today on one action against the federal government's unlawful termination of California's Solar for All grants. As Attorney General Bonta mentioned, California undertook extensive efforts to design an effective program and was ultimately awarded approximately $250 million to deliver electric bill savings to low-income, disadvantaged, and tribal communities through the increased adoption of solar and battery storage. This grant would have supported the installation of over 600 renewable energy facilities and delivered electric bill savings to participating low-income and tribal customers throughout the state. California was well underway to implement its grant and was fully compliant with the grant terms. Here's what we could have had. Community solar. We could have funded new mid-scale solar developments that provide monthly bill discounts for at least 20% to participating households. We could have had community solar projects that support tribes. A portion of our funds were designated for that. We could have had support for our solar on multifamily affordable housing, which would have prepared sites to enable rooftop plus storage deployment, exclusively serving low-income affordable multifamily housing. We could have had grants, augmented grants for existing community solar, rooftop solar programs in publicly owned utility territories. And we're also losing the opportunity to establish work training programs in solar and storage sectors with outreach to low-income communities. Despite all of these opportunities, the EPA unlawfully terminated California's grant, as well as other Solar for All grants, based on a plainly false legal argument, claiming that Congress had rescinded obligated Solar for All grants in H.R. 1. The CPUC joins the California Attorney General in challenging this unlawful termination. The termination is a short-sighted action that takes away funding that would have allowed energy projects to go forward. With the loss of this funding, we're missing a precious opportunity the opportunity to reduce costs for all California electricity customers. To be clear, the CPUC will continue our progress toward clean energy for all Californians and a sustainable energy future. I'm honored to join Attorney General Bonta and Attorney General Mays here today, and I thank them and the other attorneys general who are joining in these actions for their leadership. And I really appreciate everyone's attendance here today. Thank you very much.
Okay, I think that takes us to our Q&A portion.
If you'd like to ask a question, you may do so by clicking on the raise hand icon at the bottom of your screen. You may also submit a question through the Q&A feature. First, please state your publication when you ask your question. First question comes from Michael. You are now unmuted.
Hey all, this is Michael Zinstein of Cal Matters, Attorney General Bonta. I bet you know what I'm going to ask. Tell me more about this Court of Federal Claims process. So question one, is this the first time that California is suing the Trump administration since either California versus Education or the SCOTUS ruling on NIH? And then the second question is, game it out for us. So, I mean, there is a possibility that the district court can side with you, but the Court of Federal Claims can side with the Trump administration, or vice versa. So, like, what happens if one of those courts doesn't side with you, the plaintiffs?
Thank you for your question. This is the first time we are pursuing this dual track approach with a lawsuit first filed in the Court of Federal Claims and then a second lawsuit filed in federal district court. And the reason is some of the guidance that the U.S. Supreme Court has shared on the emergency docket or the shadow docket, in which, in particular, a concurrence by Justice Barrett in the National Institutes of Health case number 2, where she laid out her view that in order to get complete relief, both monetary damages on the one hand and also declaratory and injunctive relief on the other, a dual track approach would be appropriate. So we are engaging in that approach now. It's not the only approach that is potentially appropriate, but it's one we've sought to pursue here. And we think that in our case in the Court of Federal Claims, we can secure monetary relief based on our breach of contract theory, that these are contracts that they've been breached, that $250 million in the case of California, for example, is owed to us, and we can secure those funds through the Court of Federal Claims. Meanwhile, in the federal district court, we'll be seeking declaratory relief and injunctive relief, a declaration that this was unlawful conduct, and an injunction ordering reinstatement of the Solar for All program, also ordering that the Solar for All program be administered by the EPA, as Congress had indicated it should be, and also ensuring that there's none of California's or any of the other states' funds are re-obligated to another state, for example. So they go hand in hand. They're different buckets of relief, if you will, that Congress has, according to at least Justice Barrett, set forth. It should be secured through different courts. And so we're going through that process. I appreciate your question about potential decisions that are in tension or inconsistent. We don't expect that. We think we have really strong cases and that will win in both courts, and that will secure the monetary relief in the Court of Federal Claims, and then we'll secure the injunctive and declaratory relief in the federal district court. So don't want to preview what the courts will do, but based on our filings, the facts, the law, our own independent assessment of the strength of our case, that's what we anticipate will be the result here.
Thanks.
Next question comes from Noah. You are now unmuted.
Yeah, Attorney General Bonta, this is Noah Boston from Politico. If the Trump administration deploys the National Guard to San Francisco, will you challenge the deployment in court?
It's currently our plan. I don't see any basis for a lawful deployment of the National Guard to San Francisco, just as there was none, in our view, in LA, or for that matter, in Portland, when California National Guard were deployed to Portland. And I think the governor himself and others have recently drawn attention to the data in San Francisco about the vast improvements in crime rates, homicides going down, break-ins, or excuse me, smash and grabs for vehicles and others going down. Of course, the National Guard cannot be deployed to enforce criminal law that as a federalized guard. That's unlawful under the Posse Comitatus Act, but that seems to be the reason that Trump is trying to deploy, and let's be clear, National Guard to blue cities and blue cities only in the United States of America. But there needs to be some sort of emergency situation, an invasion, a rebellion, inability to enforce the laws with the regular forces. None of that is even close to being present in San Francisco. So if there is an unlawful deployment, a federalization of the National Guard and deployment of that guard to San Francisco, we expect to be in court immediately.
Next question comes from Joe. Joe, you are now unmuted. Joe, are you talking?
Hello?
Yes.
Oh, now. Okay, cool. This is Joe with Courthouse News. For Attorney General Mays, half my question seems to have been answered in the Q&A box over there, but I wanted to clarify the 900,000 number y'all had been referring to. If the 900,000 is the amount of homes nationwide that this would affect, my question then is how many Arizona households would it have been?
900,000 nationwide, 11,000 Arizona households.
Thank you.
You bet.
Next question comes from Dave. You are now unmuted. You have to unmute yourself as well.
My apologies. It's Dave Mason with the Center Square News website. So my question is for both attorney generals. So I'm curious about what is the cost for taxpayers for all of this litigation that's being leveled against the Trump administration, how that will be paid for, and whether you will be seeking to get the Trump administration to reimburse you for the litigation costs. And my other question too is whether we have reached the point of a constitutional crisis, and if you feel there will be need for additional legislation in Congress to redefine the role of the executive branch.
I'll go first. AG Mays?
I'll go first, I guess. Look, we've calculated this number, and you know, obviously we have a fantastic Solicitor General's office in Arizona, as does California, and all of our states that are doing this litigation that we feel is critical to our states and to the future of our country. I think we, you know, maybe spending $1 million or $2 on overall on salaries, but we've also calculated that across the 27 lawsuits, well, 27 today, 27, 28 if you count both lawsuits, we have saved Arizona $1.5 billion in funding that would not have flowed to Arizona if we had not filed these lawsuits on behalf of our state. So the ROI on these lawsuits for all of the states that are bringing them, and so far it's a just Democratic states, is enormous. The ROI on these lawsuits is absolutely enormous. So that's what I would say. And Rob, I don't know if you want to take that one.
Absolutely. Thank you. We did a calculation a few weeks back. At that point, we had spent about $5 million in our litigation. We had protected $168 billion in funding for California that the federal government improperly tried to withhold. So our ROI at that time was $33,000 and $33,600 returned and protected for California for every dollar spent on litigation. And look, we wouldn't spend any dollars on litigation if Trump wasn't acting unlawfully. All of our actions are determined based on what he does. If he acts lawfully, we don't sue, we don't spend taxpayer dollars. If he acts unlawfully and tries to harm our states, we sue him. And we protect our dollars, and we protect priceless rights that you can't put a dollar figure on, like the right to vote and the right to birthright citizenship. So they are huge returns on taxpayer investments in our cases. We are protecting billions of dollars nationwide across our states. And I think the question that should be posed is, why is Trump acting unlawfully and unconstitutionally so consistently, so frequently, so blatantly, so brazenly, requiring states to sue him and to win over 80% of the time in our cases, securing orders where courts are declaring his actions unlawful. So we will be prudent with our expenditures. We bring cases that we believe we will win, and we've been winning over 80% of the time. But the ROI is enormous in terms of what we're saving and protecting for each of our individual states based on what we're spending.
Great, thank you.
We've been asked, when do you expect the second suit to be filed today?
I would say imminently. Rob, I don't know if we have any more information on that.
And any minute, if it's not already filed, and maybe we just haven't heard of it. There's been a communication lag, but imminently is a great word.
Next question comes from Noah. You're now unmuted.
Yeah, hi there. This is Noah Boston from Politico again. Commissioner Reynolds, do you think that California should renew its funding for the demand side grid support program, or do you think that would be better to let that program sunset and let similar CPUC programs take the lead?
Hi, Noah. Thanks for the question. At the PUC, we have a number of demand side programs in effect, and then we also have an open proceeding on demand side resources. And so I'm not going to go into too much detail about the proceeding that is underway, but really encourage you to continue to track. We have lots of parties bringing information to us about the best way to harness demand side resources. We already have a number of programs, as I mentioned. California has been working on demand side reduction for many years, and we're also doing a lot of work on flexible rates, new types of rates that can match customer use with intermittent resources and really harness the new electrification that we're bringing online in buildings and in transportation.
Thank you. And that's the last question we have time for today.
All right. Thank you, everyone, for being with us. We really appreciate it.
Thank you all. Thank you, AG Mays. Thank you, President Reynolds.
Thank you. Thanks, everyone. Bye.